as has been recorded in the impunged judgment of the High Court when the writ petition was taken up for admission on 14th May 2010, the fact that the petitioners had withdrawn the condition with regard to the provision of foreign exchange rate variation was considered, and it was also observed that such subsequent withdrawal could not affect the belief of the petitioners. However, on the submission made on behalf of the petitioners that the aforesaid condition was also included in the RPF submitted by respondent number 4, notice was issued in the matter. Consequently, while taking up the writ petition for final disposal, the issues framed for deciding the writ petition were centered around the said question. In fact, the first issue which was framed was whether a bidder could amend its bid by withdrawing a condition of the bid document whereby the bid was considered to be non-responsive. The second issue, which is an offshoot of the first issue, is whether a bidder would be entitled to contend that a non-responsive bid bet it and as responsive since the offending condition was withdrawn after the bid documents had been opened. The third issue raised was with regard to the bid submitted by respondent number 4 and whether the same could be treated as responsive although the price offered by the said respondent contended a foreign exchange rate component which was to be considered at a particular rate. Deciding the said issue, the High Court held that since the terms and conditions on such representation of the petitioner, the Director Technical Education wrote to the state government seeking appropriate direction for stopping the house rent allowance of the petitioner. The stand taken on behalf of the petitioners was strongly opposed on behalf of the respondent number 4 to whom the contract had been awarded. Mr. Ashok Desai, learned senior advocate, pointed out that the condition relating to the foreign exchange rate variation and the proposal of the respondent number 4 in relation thereto indicated a firm rate of exchange as on the date of the opening of the commercial bids, and there would be no escalation of such offer during the subsistence of the contract as envisaged in the tender documents. Briefly stated, the facts are that the landlord respondent filed a suit for recovery of areas of rent and ejectment with the allegation that the petitioner was a tenant of the disputed accommodation on monthly rent of ₹5. Besides, he was liable to pay ₹20 per month as electricity charges and ₹7 per month towards house and water tax as part of rent. After completion of the investigation, charge sheet under section 302 IPC was filed against the applicant. In order to prove its accusation against the applicant, the prosecution examined in all 7 witnesses, out of whom PW1 and PW2 were the eyewitnesses. The documents prepared during the investigation were also filed in support of the case. The applicant in his statement recorded under section 317 of the Code of Criminal Procedure denied his involvement in the crime. His plea was that a false case has been registered against him. However, he laid no defense evidence, placing reliance on the evidence of the eyewitnesses and other evidence adduced on record. The appellant, as noted above, was found guilty. The appeal of the appellant against his conviction came to be dismissed by the High Court. Mr. Arvind Kumar, learned counsel, appearing on behalf of the appellant, submitted that the High Court committed a serious error in appreciating the evidence of the alleged eyewitness and undue importance to the recovery of the weapon of offense has been given. It was urged that the High Court has failed to take cognizance of the fact that no motive has been attributed to the appellant for commission of the offense. Therefore, the appellant could not have been found guilty of the charge labelled against him. Learned counsel next submitted that non-examination of the Samit Singh was allegedly lodged the first information report of the crime in the police station and honor of Sandeep Pansaf is fatal to the prosecution case, and both these witnesses were intentionally withheld by the prosecution with a view to conceal the true facts of the case. Thus, according to the learned counsel, the prosecution has failed to establish the charge of murder against the appellant beyond reasonable doubt.